faculty aspirants, and welcome to another crucial explainer from Rungta IAS Academy. I'm Faculty A, and I have Faculty B here with me. Today, we're diving deep into the GS Paper 2 governance syllabus to decode one of the most extraordinary powers of the Supreme Court.
Welcome, everyone. Absolutely. This is one of those highly analytical topics that consistently pops up, both in mains answer writing and the personality test. So I'd highly recommend keeping your notepads ready. Let's get right into it.
We need to start with a core constitutional dilemma. Think about this for a moment, aspirants. What exactly happens in our democracy when existing laws just completely fail to provide a specific remedy for a grievance?
Right. It's a critical gap. Today, we're going to decode the concept of complete justice, analyze a very recent current affairs case that you absolutely must quote in your exams, and finally, debate that very fine line between judicial activism and judicial overreach.
And that brings us directly to Article 142 of the Constitution. You see, the apex court doesn't just interpret the law. Under Article 142, it essentially acts as a constitutional safety valve. Exactly. It's what we call a residuary power. The Supreme Court, acting as the ultimate custodian of the Constitution, steps in to prevent a manifest error or travesty of justice when the statutory law is entirely silent or just incapable of addressing the grievance. Now, to write a high-scoring mains answer, you need to map the evolution of this power using landmark judgments. Take the 1991 Delhi Judicial Service Association case. The court made it very clear that restrictions contained in ordinary laws cannot act as limitations on its constitutional power. Building on that, the Canara Bank versus DeBasis DOS judgment in 2003 gave us a brilliant principle. Substantive justice, the actual removal of injustices, always takes precedence over mere legal justice. But mark this point from Hitesh Bhatnagar versus Deepa Bhatnagar in 2011. This extraordinary jurisdiction demands extraordinary care and caution. It isn't a blank check. Let's link this static theory to dynamic current affairs. Let's look at the very recent 2025 case in Polity accident versus National Highways Authority of India.
This is a prime example. The Supreme Court took suo motu cognizance here, and they effectively elevated safe travel on national highways to be an integral part of the right to life under Article 21. They made it categorically clear that safe, motorable roads are a constitutional obligation of the state, not just some policy goal.
And what actually triggered the apex court to use its inherent power here? The data is frankly alarming. National highways make up merely 2% of India's total roads, yet they account for a staggering 30% of total fatalities. It's tragic. The Polity accident alone saw the loss of 34 lives, and in just the first 6 months of 2025, we saw roughly 26,770 deaths on these highways. These devastating figures left the court with absolutely no choice but to intervene to ensure complete justice. And we are already seeing the direct, real-world outcome of this intervention. The government has adopted a comprehensive, four-pronged strategy: education, engineering for both roads and vehicles, enforcement, and emergency medical services.
Exactly. And this strategy is aimed at an ambitious goal, reducing road accidents by 50% by the year 2030. For your GS2 paper, this is a perfect example showing how an Article 142 directive directly shapes ground-level governance and administrative action.
Now, for crucial mains conceptual clarity, we have to address a very common doubt among aspirants. Can high courts also deliver complete justice?
Well, the 2009 Anil Kumar Jain versus Maya Jain case answers this perfectly.
Yes, it's a vital distinction. While high courts do have wide powers under Article 226 and can certainly deliver justice, their powers are far more circumscribed. The inherent, absolute residuary power to bypass procedural constraints to do complete justice, that belongs exclusively to the Supreme Court under Article 142. Of course, exercising such a sweeping power leads to intense debate. You'll often hear critics label the frequent use of Article 142 as judicial overreach. They argue it bypasses established laws and encroaches upon the domain of the executive or the legislature. But as a future civil servant, you really must provide a balanced view. Judicial activism is often a necessary, proactive interpretation of the Constitution. Think about it. When new social realities emerge, like live-in relationships or matters relating to homosexuality, and our established laws prove inadequate, the court has to step in proactively so justice is not denied. So, we'll conclude this explainer with a direct, challenging question for your personality test preparation. Does the frequent use of Article 142 undermine the legislature, or is it an absolutely necessary tool for our rapidly evolving social, economic, and political realities?
I want you to actively formulate your own balanced perspective on this. The Constitution is a living document, and complete justice is its heartbeat.
Keep analyzing, keep studying, and we'll see you in the next explainer from all of us here at Rungta IAS Academy.